All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. We're here for oral argument on case number CACV 16-0417, Necia Robbins, petitioner versus Robert Townsend, respondent, appellant. Counsel, I'll remind you that because we're recording this, if we ask you to please identify yourselves and your clients at the beginning of your arguments. Each of you will have 20 minutes in which to argue the case. Appellant's counsel, if you please watch the clock and reserve as much time as you'd like for rebuttal, if any. And also, please keep in mind in your comments that we've read the briefs and we've conferenced the case, so we're familiar with the basic background and the issues of the case. With that, counsel, you may proceed. Counsel for appellant. Yes, go ahead, please.
Good morning, Your Honor. John Churchill on behalf of the respondent, Bob Townsend, who is seated behind me on the left. After studying this case over the weekend and reading the pleadings and the briefs and everything over and over, I've come to the inescapable conclusion that there are, although many issues in this case, it really boils down to two things. Those are, did the lower court properly apply Arizona law to the husband's apparent execution of an acceptance of a community property deed with right of survivorship? And did the court properly apply community property and trust law to the facts of this case and make an equitable division of the property of the parties? The lower court reasoned that it did not have to apply presumptive gifts law to this case for two reasons. First reason was, well, because the husband's separate property interest was conveyed to him from his parents' trust. And secondly, because it was conveyed to the parties as community property with right of survivorship. Neither of those reasons survive logical or legal scrutiny. In so doing, however, the court completely avoided an inquiry of or a decision about the intent of the husband when he signed an acceptance to a deed. Instead, the court saddled him with the general presumption of ARS 25-318A, which says that all things acquired during the marriage are presumed to be community unless proved otherwise by clear and convincing evidence. The court kept that burden on him throughout the entire trial and even imposed to the extent that he required both parties to prove that they intended the inherited property was to remain separate, as if the wife would admit that. However, the wife is seeking to enforce a deed which was created part and parcel as a trust was being created, a trust agreement. It was a part of the agreement. And she's seeking to enforce a trust absent her conveying her most valuable asset, roughly a $500,000 savings account, which she had agreed to convey into the trust, but chose later not to.
Was it just a savings account, counsel?
Just the Boeing savings account, yes.
It's not an IRA account.
Pardon me?
It's not a retirement account?
No, the Boeing account was separate from her retirement account. Her retirement account provided her with a very convenient and comfortable pension.
And did your client agree to put in his savings accounts, if any?
Yes, he agreed to put everything in, Judge. He had no savings accounts.
Did all cash was put into the trust?
He agreed to put everything in, Judge.
And did that happen?
No, because the trust unfortunately fell down before they had conveyed everything into the trust. That was the problem. There was a breakdown when my client discovered, inadvertently, actually, when someone read the trust to him and read the associated documents, that the wife had not placed her agreed account into the trust in any manner.
How long had passed from the time that the marital trust had been created to the time that he is said to have learned that the Boeing account wasn't in it?
The parties agreed to enter into the trust in 2007. That's when my client initiated the transfer of his properties from his parents' trust to him. That's where the problem deed arose. They actually signed the trust in early, I believe it was February of 2008. They would typically spend half of their time in Montana, half of their time here. That's why there were these extensive delays. And I believe the trust was read to him by his friend Gordon Brown in, I think it was 2009 or 2010 when they were up in Montana, and his friend, who's also a retired banker, was reading the trust and brought this to his attention that that asset was not there.
Is it his position that, I mean, you said earlier that he had not put in all of his money because she had not put in.
No, he did put in everything. He put in his largest asset.
Did he put in all of his assets?
Well, they hadn't put in, neither one of them had put all of their assets in yet.
Right, but let's talk about him first.
Just,
he had not.
He had put in his largest asset, yes.
But not all.
His sole source of income, his largest asset by far was a commercial building. That was basically his only asset other than the residences they had. That was it. They had little accounts. Both of them had their own separate little, checking accounts and things of that nature. But as far as the big things, yes, he put it in. He did indeed convey it into the trust as agreed.
All right. In your briefing, you raised the issue of question you were not permitted to ask wife with regards to the transfer of her Boeing account into the marital trust. So let's talk about that for just a moment. You argue in that brief that the trial court erred when it excluded admission of wife's deposition testimony that the marital trust included her savings account, right?
She did indeed make that admission during the deposition, yes.
Okay, but at trial you did ask her the question as to whether the trust required that all of her property go in it, and you did ask her also about her deposition testimony, and she responded by saying that she didn't dispute. Let's see. Specifically, initially you asked her whether of real, personal, intangible, or mixed nature, and wherever situated, speaking of the property, whether described in that trust or not. That's what it says, doesn't it? She says yes. Then you ask, that's a very inclusive statement, isn't it? Answer, yes. Next question, that statement would include, ma'am, your what we commonly refer to as your 401k, which is actually your Boeing savings account, correct? And answer, I don't know. Bob didn't have to include any of his cash. Then later, you ask her whether she recalls being deposed. And then at that point, you confront her with her answer at the deposition as to whether her Boeing account would be included in that marital trust. And your question following is, and your answer was, I guess it does. Do you remember that answer? Answer, I don't know. Your next question, do you dispute that? That was your testimony. Answer, I don't dispute it. Didn't she then answer both in real time and also as to deposition your question?
Well, sort of. She danced around that 3 or 4 different ways, and I just wanted to get it absolutely clear. You said, I guess it does during your deposition, and I couldn't get her to go there, and that was my plan.
No doubt you didn't get the answer you wanted, but she did answer.
Sort of, the I don't know kind of, and then she finally didn't dispute what she said. Yes, I guess arguably that would be an admission, but it wasn't the admission I wanted.
It wasn't what you wanted, but she did answer yes as to the first question in real time, and then that she did not dispute that had been her answer at deposition.
Correct. She admitted that was not her answer, but she didn't admit that she agreed to do it, and that was the problem. And there's a subtle difference, and she's very cagey. I mean, you could see how long it took me to pin her down to most everything during that testimony.
Well, there no doubt was some dancing around, but it didn't preclude you from arguing that final step, that all meant all.
I tried, yes. I did believe all meant all, and so did my clients, frankly.
All right, so the questions were answered. It was just a matter of what interpretation we could glean from that.
Correct.
Okay, thank you.
Turning back to the trust, I'm still a bit fuzzy. Maybe if you could give me one or 2 points of what clear and convincing evidence, what pieces of clear and convincing evidence did your client provide that shows that the trust, that the court erred in finding the trust was community property, the trust deed, the conveyance of the commercial property by a deed?
The problem is, by the court by deciding this wasn't an issue of a gift, a presumptive gift, he took out the issue of intent. Intent was not addressed during he didn't address it at all in his finding. The question is, what was the intent of the signer of that deed?
Even if the gift presumption applied, what did your client do to rebut it?
As far as his intent?
Yes.
Well, he made it clear that, first of all, the only reason he sought to have his interest taken out of his parents' trust was to comply with he and his wife's agreement to create this new trust. And he was told by his attorney, you need to get that out of your trust so you can convey it into the trust that you're making with your wife. He contacted his brother, the trustee, essentially said, convey that property to me so I can put it into this new trust we're making. The brother apparently called a title company. We don't know exactly who it was, but it looks like a title company. They prepared a deed, send it to him. He did not review it carefully. He's not a lawyer. He said, I'm not sure what this meant. I guess this is what he wanted. He didn't know. He didn't consult with Bob. It was sent to Bob while he was in Montana. And it was basically handed to him. We're going to the bank. You got to sign this. He's dyslexic. He doesn't read. He either can't read or won't read because it's too difficult for him. He did not read this document. He did not read the deed. He did not read
or the trust.
He didn't read the trust till later. He knew what he was told what the trust meant, and he believed his lawyer. He's capable of understanding things that are verbally explained to him. His problem is reading. That acceptance might as well have been in Greek to him. He did not read it. He could not read it. And he trusted his wife. He said, he saw a document and said, well, like the wife is supposed to be on here because we're married, I guess. I said, somebody who knows more than I do prepared this, so I'll sign this without reading it. No one explained to him that this could dramatically and drastically change his ownership interest. No one explained to him that if he signed this deed, that he was presumptively giving a gift to his wife. What
did he want to do? He wanted to place that in his sole and separate property interest into the trust?
Yes. He did want to do that. That was his plan.
Okay. So then what?
That was the only thing he wanted to do.
And what was the purpose of the trust? If the parties wanted all their sole and separate assets to go into the trust?
To be distributed pursuant to the trust terms. And those were very clear. They involved certain friends. It involved their children. Each one of them had a child. And others. There was a very distinct in the trust how it was going to be distributed in the trust. That was all agreed. Part went to his son. Other parts went to her son, more went to her son, and to some friends. It was clearly a testamentary instrument. The trust was. That was what was intended. But the trust was intended before it went there to take care of the two of them. They wanted to put all their property in the trust, and they had substantial properties, to take care of them when they were older. I know $500,000 sounds like a lot. You get sick. It's amazingly not that much. And I confronted her about that. I said, you agreed everything was going to the trust, didn't you? Yes. You agreed that this was to take care of you got older. Yes. But if your story is true, you would have access to your Boeing account, wouldn't you? Yes. But Bob wouldn't if he survived you. Well, no. That wasn't the deal, was it? No. So, yes, that was the problem. And Bob did exactly what he agreed to do. By the time they were divorced, the values were very close to the same. He conveyed his property into the trust just like he agreed. That's all he intended to do. There was no evidence of an intent. He did not instruct that deed or direct that deed to have his wife's name placed on it. His brother, the grantor who signed the deed, did not direct that wife's name. She didn't direct No one instructed that deed to be prepared the way it was.
Was the trust in existence, the marital trust in existence at the time of that deed?
I'm sorry?
Did the marital trust for the parties here exist in written form at the time of the deed?
It did.
Okay.
It did. They had received the entire trust in draft form to review, and they had not signed it yet.
Okay.
But it had been prepared. It had been in their possession for roughly 5 or 6 months at the time he did this.
So to play it back, so we're on the same page, a draft existed, but the trust itself had not yet been stood up in a signed document.
The exact same draft that was signed by the parties existed. Yes, that existed.
But not signed.
It had not been signed yet because they hadn't gotten back to Arizona to sign it. They were in Colorado. Excuse me, Montana.
Now, the marital trust doesn't indicate in anywhere on the marital trust that it was the intention of the parties that the property included therein would remain separate for each of them, right?
The trust had common language which says that if the trust is dissolved, it goes the way it came in, which was if it was separate, it went out separate. If it came in community, it stayed community.
Your client's position is that he didn't understand by virtue of being dyslexic and some other circumstances at the time of the signing of the deed, didn't understand that he was receiving the property, the Kiowa property, as community property, correct?
Correct. He did not read the acceptance. He had no clue what that thing said. He just was on his understanding he had to sign this to comply with their agreement, which was to put his property into the trust.
But it's not his position that the document itself, as drafted, does exactly that. It conveys the property to both of them as community property. It says as community property.
That's what the deed says. Yes. Had he been able to read it, he would have been able to see that. He did not read it. He can't read. The adverse attorney gave him a letter, and he went a few words into it and said it'd take me all day to get this figured out, and I don't know if I'd do it then.
And your brief also indicates that he was under the influence of alcohol at the time he signed?
Well, back then he was under the influence of alcohol quite a bit, yes.
Okay, and so isn't the onus on the person signing to know what they're signing, as opposed to signing and then later saying that they're not able to read or have someone else read it to him?
I would say that a non-dyslexic would have that obligation, yes. The problem is he believed that someone who knew more than he did about preparing documents prepared this document, and this was what he was supposed to sign.
But he doesn't know where it came from.
He actually thought it came from his attorney. And later on in his testimony, I thought Mr. Bean was the one that did that because he was the only one that knew all this stuff. So he had every reason to believe that it was done correctly. He's a very simple man. He's a very simple, trusting person. There was a time when that was something that was coveted and valued. Do I have 3 minutes left?
Yes, Counsel.
Can I reserve that for
Yes.
rebuttal?
Yes.
Thank you.
May it please the court, my name is Stanley David Murray, and I'm the attorney for the appellee, Nesia Robbins, who was the petitioner in lower court proceedings. I was hoping we'd get to about all 4 issues that were briefed, but apparently the court is concerned about the trust, so I'd like to address that, and I might be short as far as my time is concerned up here. The parties did agree to commence a marital trust where they would take care of each other and then have the trust distribute those assets. So they met with an estate planning attorney named Mr. Bean. I don't know his first name. I don't know if I'm pronouncing his name correctly. But he had the parties prepare an inventory of all the property, which is the basic practice of any estate planning attorney. Even us divorce attorneys have to make sure we have full disclosure of assets, whether we're handling a divorce or estate planning. And so, yes, the Boeing account was listed. All of her assets were listed. All of his assets were listed. That doesn't mean that all of those assets were to go into the trust. Mr. Churchill keeps referencing language from the decree or from the trust that says all property is to go into this trust. But Mr. Bean explained that as a catch-all phrase to cover non-titled items like appliances and furniture. So when you do have titled documents or titled property, you do have to prepare the documents properly. And all Mr. Townsend, the appellant, had to do was transfer his trust interest in his family's trust directly into this marital trust. He didn't have to convey it to himself and his wife, the appellee. Directly into the trust was all that needed to be done. So the fact that he had this this deed drafted up that listed both him and my client as husband and wife, community property with right of survivorship, shows an intent on his part, which doesn't need to be explained, that this is to be held as community property to be transferred into the trust as community property. So it's the law of conveyances that applies here, not the law of trusts or the law of contracts. Deed says what it says. He made a, I don't want to say he made a gift, because actually I agree with the trial court, where the trial court said it came from the trust to the community, not from husband to wife or wife to husband. So he didn't have that spousal exchange, if you will.
It's not the Toth classic.
No, exactly.
Toth type
Yes, sir.
exception.
So it's simply a conveyance from the trust. Community has acquired a property interest now. So the trial court was correct in defining it as an acquisition rather than a gift. Now, Mr. Churchill, in his brief, mentions the Yano case, which talks about if you make a unilateral mistake, you're entitled to reformation. But the important distinction in Yano is that it's about a gift and whether that gift was made under the terms the gift was supposed to be made, if I'm making any sense. In Yano, the trustors wanted to put the property into a life estate for them, a remainder to their children. But instead, the deed said fee simple to the children. That was not their intent. But it was still their intent to make a gift. And so the law of reformation, when it comes to gifts, allows unilateral mistake to permit the reformation of that deed to express the intent of the grantors. In this situation, again, we don't have a gift. And besides, Mr. Townsend is arguing, the appellant is arguing, he never intended a gift in the first place. So it's not a situation where the Yano exception for unilateral mistakes applies to reform that deed. And the main thing is, why didn't he look at this deed? I understand he's dyslexic, but I'm sorry, if you sign something or if you accept a document and you submit it, record it, you're supposed to know what's on that document, and you have an obligation to read it and make sure it expresses your intent.
Counselor, are there no circumstances in which one can sort of back up the truck and get
Oh,
out
sure.
from underneath the deed?
Fraud or duress, which wasn't alleged in this case.
Just, I mean, here he's alleging it was simply not his intent to do that.
And we have to depend on documents and the law of conveyances to say what they say and mean what they mean without having to look at the intent of the parties. It's almost like the parole evidence rule in a contract. Well, I signed this document, but I didn't intend that. Well, the parole evidence won't come in to alter the terms of a contract. I think the same rule would apply with a deed, especially since it's recorded.
So there's no showing Mr. Townsend could have made, no factual setting with respect to mistake, setting aside fraud or duress or something like that. But your position is, once it's signed, that's it.
Certainly no clear and convincing evidence. Yes, sir.
Well, my question's a little different. My question is sort of is a hypothetical. Is there any, could Mr. Townsend have made any showing based on mistake? Let's say he proved mistake beyond any reasonable doubt. Is your position that wouldn't matter, or is your position that didn't happen here?
Unilateral mistake would not apply in this situation because it wasn't a gift, Your Honor. And I believe the trial court was correct in determining that it wasn't a gift.
Counsel, was there any benefit to husband in taking the property out of the Townsend Trust and receiving it as community property with his wife?
Was there any benefit?
Was there any independent other benefit? He had a beneficial interest in it. So what was the
Certainly.
benefit to him?
Well, he maintained that beneficial interest because now it's community property, so he's sharing it with his wife. But apparently he was still collecting the income from that property during the marriage, and I suppose it went to community purposes. But nothing really was altered as far as the way that trust was managed, that particular asset was managed, rather. So I don't know in terms of benefit bargain. I don't really know if that would apply, Your Honor, because we're not talking about a contractual bargain for exchange here. We're talking about simply an
Right.
acquisition. So But I do think the parties just kept the property treated the way they treated it before, with Mr. Townsend collecting the rents and using it to pay community expenses. Also, important facts to determine here, the important basis for this ruling was the trial court's determination of facts. And findings of fact, as this court knows, are not set aside unless clearly erroneous. There's also credibility issues and the weight of the evidence. The trial court weighed the evidence, the documents that were presented, the testimony of the parties, and found wife to be more credible than the husband was. I don't know if the court can intervene in that sort of situation unless, again, it's been clearly erroneous findings.
Was it equitable for husband to have to put what we've heard is his major asset into the trust, but not for wife not to have to do the same thing?
That was the way the trust agreement was written up. Whether it's equitable or not is not really a question for the trial court, because it's the parties' agreement to do with the property the way they want to.
The court has to make an overall determination that I mean, as
at distribution.
In division, yeah, at distribution, that the court is dividing all these things up equitably.
Sure, but at the time of the formation of the trust, the parties are free to deal with their sole and separate property as they choose. So I don't know we have any equitable principles coming in here. If he wants to give away the house, or the business rather, fine. It's up to him. Let me back up, too, with the 401k plan.
So it was a 401k?
That's what I thought it was, but I didn't do the trial, so I'll have to defer to Mr. Churchill on his interpretation. But it's, as Mr. Bean testified, the IRS doesn't allow you to put retirement benefits into a trust. Apparently, you've got to do some machinations, and you have tax consequences, and he doesn't advise it. In fact, he said the parties did not even discuss it. The parties did not discuss putting that 401k plan into the trust. So again, an issue of credibility for the trial court to determine. I was going to talk about the Montana property. I don't know.
Counsel, before you get there, Judge Cruz had asked you about your client's testimony, both at trial and deposition, about the breadth, her understanding of the breadth of the trust and whether it included what I've been referring to as the Boeing account, regardless of its configuration. What's your response to that?
It seems to me she didn't understand the provision, the catch-all provision that Mr. Bean puts in his trust agreements, that all property was to be included. As I explained earlier, Mr. Bean testified that he puts that in there to cover non-titled assets as well as the titled assets.
Is it that she didn't understand it, or that she understood it in a way different, perhaps, than the attorney who drafted it?
Boy, I can only speculate, Your Honor. I just know that she did not intend to put the 401k into that plan, and Mr. Townsend didn't stop to say, when he signed the trust agreement, wait a minute, where's your 401k plan? So it seems to me, under the circumstances, the parties did not intend to put the 401k plan into that trust agreement, or Mr. Townsend should have said something a lot sooner. On the Montana property, I don't know if the court needs to hear about this, but Mr. Churchill in his brief talks about how, oh my gosh, you didn't disclose that it was flooded during the trial. Well, what do you think would have happened during trial if she had disclosed that? I'm sure Mr. Churchill would have argued late disclosure, inadmissible, or raised some other issue about this coming up so suddenly and so late. But even if my client had brought that up, she would be able to argue that the property is worth even less than what the court found it to be worth. The appraisal that she had submitted was based on non-flooded situation back in November, prior to that, but the flooding occurred in November, and then the trial was in December, I believe. So there's no loss or any harm caused to the appellant in that situation. The court properly considered the value of the property and awarded it to my client. But note also there's an equalization payment that my client has to pay to Mr. Townsend, some $33,000. So there is an equal distribution here as far as the properties that were awarded to both parties, with wife getting the Montana property and husband getting the Lake Havasu City property. I don't believe they mentioned the $33,000 equalization in the brief. Finally, we are asking for attorney's fees. There isn't much of a financial disparity between the parties, but we believe the positions taken in this appeal were unreasonable and weren't justified because, again, abuse of discretion applies, credibility issues, and weight of evidence solely with the province of the trial court. And unless the court has any other questions for me?
Questions? No,
Thank you very much.
Counsel?
I wish I could talk like an auctioneer. There was a statement made that, well, they could have put this, Mr. Townsend could have transferred his property directly from one trust into the other. That's not true. Mr. Bean, at page 72, lines 8 through 12, made it very clear that the proper way was to transfer it out of the trust to the individual and then from the individual into the trust. That's exactly what Mr. Townsend did, which is, it was his lawyer's instruction. He understood he had to do that. That's page 72, lines 8 through 12, in day 2, I believe. In any event, this case is very similar to Austin. In Austin, Valor Austin was not, she signed trust agreements prepared by lawyers, wasn't explained to her that this would could make a dramatic change in her property interest, in her separate property interest. That this could be creating community property interests. It could be a gift. No one explained any of these things to her. And the court said, hey, you've got to be fair and equitable. You've got to you have to know what you're doing before you start conveying your property away. That's why you look into intent, which is what the judge avoided in this case. And in Austin, Valor Austin was not dyslexic. She just didn't know the consequences. And the court said, you got to know what you're doing when you're conveying away your separate property. And especially, this is this gentleman's retirement. He's in his 70s. He can't make another retirement. This was his income. This is it. He doesn't have another chance. To suggest, as the petitioner's counsel did, that giving him his property back would be a windfall. I don't see how having his property interest, having his income, and doubling or more than doubling the spouse's income and assets, where's the windfall there? I'm asking you to put this gentleman back to status quo ante, which is actually what trust law requires. When a trust fails, you put the parties back to status quo ante. Trust law was ignored as well. I tried to educate the court on it. It was ignored. So on Austin, the In re Harbor requirement that something has to be executed with full knowledge of the property involved and the rights therein, and be fair and equitable. What is fair and equitable? And where was the inquiry about fair and equitable with one person not contributing all of their property, as they agreed, and then taking half of the other party's property and doubling the value of their own? Where is the fairness and equity in that? I respectfully submit that was not a fair and equitable distribution. And as you know, my client couldn't even get an opinion on the value of their home into the record. He couldn't even get an appraiser to look at it after substantial improvements had been made on it. So here we are.
Okay. Counsel, thank you. Thank you both for your arguments this morning. The court will take this matter under advisement, issue a decision in due course. We'll take a brief recess to prepare the courtroom for the next argument. Thank you.